This is Michael Popok, Legal AF. Donald Trump would like to be done with federal Judge Lewis Kaplan, and I'm sure the feeling is mutual in the E Jean Carroll case. In less than 72 hours, this federal judge has issued an order in which he called, in no uncertain terms, Donald Trump a rapist. Donald Trump spent most of the last 3 weeks acting like he was vindicated, or at least since May, that he was vindicated by a jury in New York. Try this spin. Because they only found him to be a perpetrator of sexual assault and battery on E Jean Carroll, but not of rape, which is only because there's a hyper-technical definition in New York criminal code about rape having to be with a penis. And the jury concluded that they couldn't figure out from the testimony whether it was his finger or his penis. And so they went with finger. And it was, to quote the federal judge, that's digital rape then, right? A digit is being used. You're a rapist. He said it 3 days ago, and he said it again in an order on another case related. There's two E Jean Carroll cases, which provides the federal judge with two opportunities in separate types of motions to call Donald Trump a rapist. And that led to the scene today, kind of unprecedented. We have a House of Representative member, Ted Lieu of the 36th Congressional District in California, who took to the floor of the House and read into the Congressional Record Judge Kaplan's ruling today, in which he declared Donald Trump, the former president, the former 45, a rapist. I'll show that clip towards the end. So that happened. Let's start with Lewis Kaplan, who is doing his job, but he's not pulling any punches about how he feels about Donald Trump or the weight of the evidence against him or the jury's verdict. Let me explain that there were two E Jean Carroll cases. There are two E Jean Carroll cases. There's one that went to trial, and there's one that's going to go to trial. The one that already went to trial and resulted in a jury verdict in May, okay, that we call E Jean Carroll number 2. And that has to do with defamation statements that Donald Trump made to deny that he sexually assaulted or raped E Jean Carroll, that he made after he was president. So there was no argument at all that he had some sort of presidential immunity to defame her. And so they went to trial on that one. And the jury overwhelmingly, 9-0, 6 men, 3 women, found for E Jean Carroll in every way, shape, and form. They found that she was sexually battered and assaulted. They checked the box. They checked the box for her having emotional damages, for having professional reputation damages, for her having punitive damages. And they awarded her $5 million. But that didn't end the case. There was always E Jean Carroll 1, which had to do with statements Donald Trump made in 2019 while he was still president. Now, that case kicked around for a while because there were issues about presidential immunity. And it took 2 separate appellate courts, one federal and one local, to kind of come to the final conclusion that that's an issue for the jury about whether he was inside or outside the scope of his immunity. The Department of Justice also jerked around for a couple of years, both under Trump's original administration and then even under Joe Biden, until just 3 weeks ago they said, you know what, we're throwing in the towel. We're no longer going to argue that Donald Trump was entitled to presidential immunity for defaming E Jean Carroll and denying that he had raped her. And so they backed out, and the judge said, great, we're going to go to trial. And we're going to go to trial January the 15th of 2024. And the other side, E Jean Carroll's side, said, we'd like to amend our complaint, which is the pleading, the main document that they use to frame the case. And so they did a search and replace. It was very simple. Everywhere where the original complaint said that he raped her, they put he sexually assaulted her. All right. And then they also added the new conduct by Donald Trump in the beginning of May at CNN Town Hall, in which he also said she's a fraudster, a hoaxer, trying to shake him down, doesn't know her, not my type, and all the other despicable things. And Donald Trump's lawyers have always thought that means that she's suing for the statements made in the town hall and for punitive damages. And the judge today told them, you don't understand the case or the legal concepts. You're not grasping the legal concepts. So let me explain it to you. They are not. E Jean Carroll is not suing on a claim because your client allegedly defamed her at CNN Town Hall in May. They are using that to show malice, common law malice, which is ill will, hatred, and the like, that's necessary to support punitive damages. Remember, she's going for $10 million in punitive damages on her main case, the main case being statements he made while he was president in 2019. They're only using the new evidence of the CNN statements to demonstrate his ill will and hatred and malice towards her to support punitive damages. And the judge says, you don't get it. So don't come to me and tell me, this is the order today, and tell me, Trump's lawyers, Joe Coloring Book Tacopina and Alina Habba, that your client had some sort of privilege to make those shameful statements at the CNN town hall, and that somehow that undermines their ability to use that evidence. It doesn't, because they're not using it as a fundamental claim, as an underlying claim. They're using it to support punitive damages. See? And he then took on the other argument that they made when they tried to object to the new pleading in E Jean Carroll 1, when they said, we don't like to search and replace. That changes the whole color of the case. That makes an extraordinary change to what this case is about. The judge says, no, it doesn't. It doesn't. It doesn't change the focus of the case one iota. In fact, it's exactly the same case, because sexual abuse is effectively the exact same thing as rape in the common parlance. And therefore, your claim to try to dismiss the complaint is without merit. That is it. So and I'll read from his Judge Kaplan's actual order. He said, and I quote, Mr. Trump's principal argument is just wrong. As this court explained in its recent decision denying Mr. Trump's motion in Carroll 2 for a new trial on damages or other relief, the Carroll 2's jury's answer to the special verdict question concerning whether Mr. Trump raped Miss Carroll established only that she had failed to prove that he penetrated her vagina with his penis. Indeed, the jury's finding that Mr. Trump sexually abused her implicitly determined that he had penetrated her vagina with his fingers, a form of rape as that word often is used. In consequence, even if the jury's response to the rape question in Carroll 2 had issue preclusive effect, in other words, it's already been determined, a matter on which the court does not express a view, it would not have the effect that Mr. Trump contends. Representative Liu went even further in reading into the Congressional Record more of Judge Kaplan's ruling. First, I assure you, first time in American history, a federal judge orders finding a former president committed rape was read into the Congressional Record. Let's play Representative Liu.
On July 19th, 2023, federal judge Lewis Kaplan rejected Donald Trump's request for a new trial and confirmed that Donald Trump raped E Jean Carroll. I'm going to submit this court ruling into the Congressional Record, and now I'm going to read you what the judge found. On page 43, the judge wrote, Ms. Carroll testified that the sexual assault, the rape, of which she accused Mr. Trump, involved especially painful, forced digital penetration. The judge further writes, the testimony of the outcry witnesses, Ms. Birnbach and Ms. Martin, corroborated the essence of Ms. Carroll's account of a violent, traumatic sexual assault. On page 44, the judge wrote, the jury's finding of sexual abuse therefore necessarily implies that it found that Mr. Trump forcibly penetrated her vagina. The judge further writes, in other words, that he raped her. I yield back.
So extraordinary further developments in civil cases involving Donald Trump. We talk a lot about the impending third indictment of Donald Trump, likely this week, later in the week, by Jack Smith, who will have racked up 2 notches on his gun belt against Donald Trump in less than 2 months, and the other indictment that's sitting up in New York with the Manhattan DA's office. And we're still waiting for the end of July, beginning of August, for Fani Willis in Fulton County, Atlanta, Georgia, to come up with her sprawling civil conspiracy indictment. So by the time this month is over, or by the time the calendar page turns to August, Donald Trump will be, without doubt, indicted 4 times by state and federal prosecutors for conduct before he was president, while he was president, and after he was president. And that's because of all of his misconduct, bad conduct, and criminal mind. I'm going to follow, whether it's civil cases or criminal cases, any attempt by the justice system to bring Donald Trump and others to justice and accountability. I'm going to follow him on hot takes just like this one, in only one place, the MeidasTouch Network. You knew that. You're watching me here on the YouTube channel for MeidasTouch. You can free subscribe, and you can get our YouTube videos, including our full-length podcasts, live recordings, and audio recordings on Wednesdays and Saturdays on a show at the intersection of law and politics called Legal AF, which I co-anchor and co-founded. And then if you like what I'm doing, you can pull it all together and look at my playlist on YouTube for MeidasTouch and find all my content listed there. You can follow me on social media at MS Popok, including on Threads. This is Michael Popok, Legal AF reporting.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.